This next phrase I'm going to be saying a lot here on Legal AF, the YouTube channel. Breaking news. Another temporary restraining order entered by a federal judge against Donald Trump and his administration. If you're playing at home, it's temporary restraining order number 6. This one coming courtesy of Senior Judge George O'Toole in Boston, who has issued an injunction to stop the Musk buyouts of federal workers, where he tried to lop off all of the federal civil servants by giving them a fork in the road memo. His words, not mine. The fork memo. Well, this judge said, fork you. He's not going to have a deadline to try to stampede federal workers into accepting by the 6th of February until he gets his mind around this issue on an injunction. So he's issued a temporary restraining order subject to another temporary restraining order and an appearance in court on the 10th of February, subject to a future preliminary injunction. Confused? You won't be when I'm done. Elon Musk, on behalf of the administration, sent out the same effing memo that he sent out when he took over Twitter and made it X. A fork in the road. What's the fork? You either resign or you're fired. You ride or you die. And in order to stay with the Trump administration, you have to pledge some sort of loyalty and fealty and some sort of weirdo MAGA test. Well, 2% of the federal workforce said, yeah, I'm out of here. And 40,000, it's the number, try to take the Musk buyout offer. And others, represented by the unions, represented by the civil service administrations and things like that, said, this violates our civil servant rights. This violates our union rights. This violates law. This is arbitrary and capricious. Why are we being stampeded into doing something illegal? So they filed their suit in Massachusetts. You're going to be hearing a lot about suits filed against the Trump administration in places like Massachusetts and Rhode Island and New Hampshire and up and down the East Coast, right? Just think of all the old colonies. We're going to be spending a lot of time talking about the old colonies and those judges against Donald Trump. This is the revenge of the democratically appointed judges, if you will, against the Trump administration. We're only let me get the math right. We're only 18 days into the Trump administration, and we already have Donald Trump's Department of Justice is 0 for 7. 6 temporary restraining orders, 1 preliminary injunction. Let's talk about this one. The judge, this is what judges do. Most of what we're going to see against the Trump administration is going to be in the form of a request for a temporary restraining order, which is telling the judge that they believe that it's more likely than not that they're going to win the ultimate trial in the case, that they are on the right side of the argument of the angels. They're on the right side of the law. They're on the right side of the facts. And the judge should look at it right now and make a decision to say that they're going to win, that the balance of equities tips in their favor, that they're going to suffer irreparable harm without it, and boom, give me the temporary restraining order. Judges will do that if they think it's more likely than not that party's going to win. They look at that first. If that happens, there's a stay in the case. It preserves what's called the status quo, which is the condition that existed before the bad thing was done. So like, in other words, forget the Musk fork memo, fork it. And let's just focus on before. Take the Wayback Machine. Now, we'll have a full-blown hearing in X amount of days. That's what Judge O'Toole is saying. We'll come together on the 10th of February. We'll talk about these things. But he didn't want this deadline, this phony, fake, stampeding deadline of February 6th to negatively impact this group of people that are civil servants and public workers for America. That's the temporary restraining order status. I think he'll formalize the temporary restraining order sometime after the 10th of February, and he'll keep it in place until he has a preliminary injunction hearing, which is on a fuller record, more evidence, more testimony, same as law. I mean, the law really doesn't change in a week or two. And then he can decide whether it is more likely than not that these parties that have asked for the injunction are going to succeed. And the injunction, if successful, would be to block and stop this whole buyout process until the judge can have a full-blown trial on the issues in 2, 3, 4, 5, 6 months. That's the injunction hearings. Many of what I'm going to be talking about here on Legal AF is going to take the form of a complaint. That's the operative pleading that's filed, accompanied by an emergency motion for temporary restraining order, followed by the judge doing a couple of things. They can do an administrative stay just to get over the weekend and let the parties get their papers together, catch their breath, then have a full-blown TRO hearing on the way to a PI, preliminary injunction hearing, on the way to a trial. At the PI hearing level, when the court blocks the Trump administration for the what looks like to be the 7th time, somebody can take an appeal. This will be a First Circuit appeal coming out of Massachusetts, which is a liberal circuit, which is covered by one of the more liberal justices on the United States Supreme Court. You see where this is going? So if you thought that the Trump administration or the Trumpers, MAGA, knew how to file cases in Texas, Alabama, and Florida, well, we know how to file cases in the original colonies, or at least the ones in New England and in the West Coast, and get the same result. So I'll continue to follow it all. The next steps here are going to be, I think the TRO is going to be put in place. I think the judge is going to side with the movements here. I think he's going to put an end to the buyout process. I think he's going to do the same thing on the preliminary injunction. And I think that they're going to take it up to the first. I think the first is going to rule in favor of the movements and kill this program. And whoever doesn't like it can try to take an appeal. And if the appellate court, the first department makes a ruling that people don't like, they can take it to the United States Supreme Court if they're interested. We'll have some of the Trump administration policies. The Supreme Court's going to find interesting, and they're going to want to get involved. Others, they're going to be like, nah, we're not really interested, or they don't think the lower level appellate court did anything wrong. That's where justice is meted out in our country. It's mainly at the trial court level and the appellate level, not at the United States Supreme Court level. There's only 60 cases out of tens of thousands that end up at the United States Supreme Court. So that's why it's so important to file in these places with favorable trial judges and favorable appellate court judges, because that may be your justice. It may end, the train might end right there with no other relief to go to the Supreme Court. And that's what we're watching. We're watching the process in action to protect the rule of law, and it's working as long as you're in the right courts. That's just all I can say. And that's why we're only 18 days in, and the Department of Justice is already 0 for 7. Not only are they 0 for 7, but let me make a point as a trial lawyer and as a federal trial lawyer and an officer of the court in those courts. The Department of Justice for Trump is losing valuable credibility that they need for future cases with these federal judges, because they're taking ridiculous positions that are unsupported by the law or the facts, that are intellectually bankrupt, and they're getting caught right away by federal judges. They're like, that doesn't make any sense. Do you have a case to support that? There isn't a case to support that, is it? Is there? This is a best of the comments so far by federal judges. My case is not going to be the first case. There's comments like that. Your comment is that the Trump administration can actively be prejudiced against groups and it'd be constitutionally okay? You see where this is going. Ridiculous positions that they're being forced to take, or they're willingly taking, and they're getting their head handed to them by judges who are not giving the Department of Justice the benefit of the doubt. You think Eileen Cannon, the judge at Mar-a-Lago, wasn't giving the Jack Smiths of the world the benefit of the doubt? I assure you, the rest of her federal colleagues in New England, in all the way down to Maryland, in the DC courts, in Washington, Oregon, and California, are doing the same thing to the Trumpers and the Department of Justice people that are coming in there. I'll continue to follow it. You're here on Legal AF. Help us continue to grow this pro-democracy channel. So until my next reporting, this is Michael Popok. In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.